Hello everyone, today in this video we will discuss about the post-incorporation compliances of a Section 8 company. No doubt a Section 8 company enjoys a lots of benefits and exemption from government. However, there still exist certain post-incorporation compliances that needs to be mandatorily followed by a Section 8 company. So now we will discuss some of the post-incorporation compliances. First one is the opening of bank account. So after formation of a Section 8 company, the first and the foremost step is opening of a bank account in the name of the company. Now, for opening a bank account, you may require documents such as the copy of the Article of Association, copy of Memorandum of Association, challan copy of spice form, copy of PAN card, copy of board resolution, certificate of incorporation, and any other document as may be demanded by the bank officials. Next comes the first board meeting. Section 8 company is required to conduct their first board meeting within 30 days from the dates of its incorporation. For this, a proper board notice be served to all the directors of the company. After this comes the deposit of share capital money. So once a bank account has been opened, the next compliance is depositing of share capital money in the said bank account, which they have to comply within 180 days from the date of incorporation. Next comes the issuance of share certificate and the payment of applicable stamp duty. So a Section 8 company is under an obligation to issue the share certificates to the shareholders of the company within 60 days from the date of incorporation and pay the stamp duty applicable within 30 days from the date of allotment of the shares as per the relevant stamp act that is applicable in the respective state. Next comes the appointment of auditors. Every company is required to appoint its first auditor within 30 days of incorporation, and the same shall be made by the Board of Directors. In case the Board of Directors fails to appoint the same within the period of 30 days, then the shareholders of the company shall call an extraordinary general meeting for appointing an auditor. The appointment of the auditor through shareholders must be completed within 90 days from the expiry of the 30 days from the date of incorporation. So the next compliance is affixing sign board. Upon registration of Section 8 company, the same is required to affix its name at every place where it is carrying on their business. Next one is printing of letterheads. Section 8 companies have to print the following information on all its business letterheads, billheads, letter papers and other forms of communication. So the information to be provided are like the name of the company, address of the registered office, SIN number, GST number, telephone number, email ID and website address if any. Then comes the disclosure of interest. At first board meeting, every director is under an obligation to disclose his interest in any company, firm or body corporate. Any changes in the disclosures shall be intimated by the director to the Board of Directors in its first meeting during each financial year. If there is any independent director, he must give a declaration that he meets the criteria of independence during the first board meeting as a director. Next comes the maintenance of statutory register. It is mandatory for a Section 8 company to maintain the following statutory registers at the registered office of the company. So these registers are first of all MGT1, which involves the register of members, MGT2, which is the register of the debenture holders and the beneficial owners, MGT3, which is in respect of the foreign register of members, debenture holders and other security holders that reside outside India. Next one is Form SH2, which is a register of renewal and duplicate share certificate. Form HS3, which is in respect of the register of sweat equity shares which has been issued by the company. Next is Form HS6, which is a register for the employee stock options. Form HS10, the register of shares or the securities which have been bought by the company or the directors or the key managerial persons. Form CHG7, which is in respect of the register of charges which have been created by a company in a specific financial year. Next is Form MBP2, a register in respect of the loans, guarantee and security or even the acquisition by the company. Next is Form MBP3, which is a register of investment which is not held by the company in its own name. Lastly is the Form MBP4, which is a register of contracts or arrangements in which the directors are interested. After this comes the declaration of commencement of business. So as a post-incorporation requirement, every Section 8 company is required to file a declaration of commencement of business within 180 days from the date of incorporation. Then comes the professional tax registration of company. It is mandatory to obtain professional tax registration for a Section 8 company in respect of its all directors, designated partners and its employees. However, all the union territories including Delhi and Haryana, Punjab, Rajasthan and Uttar Pradesh does not have any law in respect of tax profession. Last comes the trademark registration. The Section 8 company should make immediate provisions for the safeguarding interest of trademark, copyrights and patents by making an application at the trademark site. Application of trademark is not mandatory for a Section 8 company, but it is strongly recommended to apply for the registered trademark owing to its huge legal infringement of right benefits. Thus, we can see that a Section 8 company is under obligation to comply with basic legal framework. Post-incorporation compliance for Section 8 company is very essential. So this was all about post-incorporation compliances. In case you have any query regarding post-incorporation requirement of a Section 8 company, contact Rajput Jain & Associate, or you can also visit our website carajput.com. Thank you.